You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand dictation number 411 and the dictation speed is 100 words per minute. Ready? Start. The case of the prosecution in brief is that the appellant had a land dispute with the deceased. The allegation against the appellant is that on 2nd March 2013 he assaulted the deceased. After that, he caught hold of the deceased by her hair and dragged her up to the village pond. The appellant put her head inside the pond water. The deceased was suffocated to death. The first informant, Raman, PW4, informed the police that Himani Devi died due to drowning. Accordingly, an FIR was registered. After the completion of the investigation, a charge sheet was filed against the appellant. The prosecution examined 10 witnesses. There is no direct evidence. The prosecution relied upon evidence of PW1 Saloni Devi, the village officer. The prosecution case is that the appellant made an extrajudicial confession before the witness. The prosecution relied upon the evidence of PW5 Chaprasi, the brother of the deceased. According to PW5, he saw the appellant holding the hair of the deceased and was taking her towards the pond. Though PW1 was declared hostile, the trial court and high court relied upon a part of her testimony. The courts also believed the testimony of PW5. The learned counsel appearing for the appellant as amicus curiae has taken us through the post-mortem report and testimony of relevant prosecution witnesses. Based on the evidence of PW9, Dr. Ram Kumar, his submission is that the death was due to drowning and the prosecution has not discharged the burden on it to prove that it was a homicidal death. He submitted that evidence of PW1, who was declared as hostile, cannot be believed as in the examination in chief. The witness did not depose that the appellant made a confession of killing the deceased. However, in the cross examination made by the public prosecutor, the witness purportedly stated that the appellant confessed before her about killing the deceased. He submitted that evidence of PW1 cannot be believed. As regards the evidence of PW5, he stated that though the witness deposed that he saw the appellant dragging the deceased towards the pond, PW2 Bala, who was allegedly present at that time, did not support the prosecution. Moreover, another witness, Lakhan, was allegedly present there and was not examined by the prosecution. He pointed out that the incident happened in the evening and PW10 investigating officer admitted that there is a temple near the house of the deceased and other people lived nearby. He would therefore submit that the prosecution has failed to prove the appellant's guilt beyond a reasonable doubt. The learned counsel, appearing for the respondent state, submitted that in her cross examination made by the public prosecutor, PW1 has clearly deposed about the confessional statement made by the appellant. He submitted that evidence of a hostile witness need not be rejected in its entirety and that the court can always rely upon a part of the testimony of such a witness. He submitted that the evidence of PW5 proves that the appellant was last seen together with the deceased and at that time he was holding the deceased by her hair. He submitted that this evidence is sufficient to hold that the death of the deceased is homicidal. He submitted that in view of the oral testimony of the said two witnesses, the appellant's guilt has been established. We have carefully perused the evidence of prosecution witnesses and other documents on record. The prosecution is relying upon the extrajudicial confession made by the appellant before PW1 and evidence of PW5 of last seen together. The case of the prosecution is that after an altercation with the deceased in her house, the appellant held the deceased by her hair and dragged her to the village pond. The prosecution is relying upon a site map. It shows that a road separates the pond and the house of the deceased. The sketch shows the existence of a ridge around the pond and two temples on the ridge of the pond abutting the road. The temples are exactly opposite the house of the deceased. According to the prosecution case, the appellant dragged the deceased by holding her hair from her house up to the pond. Between the house of the deceased and the pond, there is a road and ridge of the pond. This means the appellant must have dragged the deceased for a considerable distance. The postmortem report records explicitly that no mark of any injury were found on the body of the deceased. In his evidence, PW9, Dr. Ramkumar reiterated that there was no injury mark on the body of the deceased. If the prosecution story of the appellant dragging the deceased was true, there would have been some injury on the body of the deceased. Therefore, the absence of any injury marks on the body militates against the prosecution's case. Evidence of PW9 shows that salt water was found in the trachea and lungs of the deceased. Perhaps to find out whether the water found in the trachea and lungs of the deceased was the water in the pond. Samples of water from the pond were collected and sent to the laboratory. That is what PW10, the investigating officer, has stated in paragraph 11 of his deposition. He further stated that the director of the State Judicial Laboratory returned the samples without testing them on the ground that the cause of death was established in the post-mortem notes. According to PW9, the cause of death was due to drowning. However, he was unable to state whether the death was homicidal or accidental. The reason is that it was difficult for him to state whether deceased immersed in water herself or she was forced into water. In fact, in postmortem notes, PW9 stated that an expert's opinion should be sought. Admittedly, an expert's opinion was not sought. Now, we turn to evidence of PW1. She was a village kotwal. She was a signatory to the Panchnama of the recovery of the dead body and a signatory to the sketch of the site made by the police.